Okay, so now we're going to move into talking about something that, I know there's a lot of different time periods that are going to be thrown at you here, but we're going to talk about Senate Bill 5160 and we're going to talk about House Bill 1236, both of which have passed the legislature this year. And some of you have already started to get familiar with the requirements of it, but it's really important to know it in its detail because this is going to be around. This is state law. This is going to be around from here on out. Unlike a bridge moratorium that's going to expire here in a couple months, Senate Bill 5160 is going to be with us. The requirements are going to be with us. But even within Senate Bill 5160, there's certain time periods that you have to pay attention to. And we're going to go through all of those, hopefully in the detail that you need to fully understand it. So Senate Bill 5160 was effective on April 22nd of this year. House Bill 1236 was effective May 10th. These aren't laws that are going to go into effect at some time in the future. They're effective now. And as we knew from the bridge moratoriums, particularly with House Bill 1236, it's in effect now, right? Those evictions could go forward now. And with Senate Bill 5160, things like the payment plan are directly incorporated into the bridge moratorium. So we need to know what's in Senate Bill 5160. One quick note before we get into this information, and we're going to go through about 40 slides. So at some point I'm going to have to move a little bit more quickly. But the proper way to view these are almost all tenant protections. These weren't necessarily created to facilitate the eviction process for tenants. It was meant to protect them in a lot of different situations. And I think anybody who looks at this language any differently would be reading it wrong. So let's just start going through this. So Senate Bill 5160 created some specific tenant protections. Landlords can't impose late fees until 6 months after the expiration of the moratorium, which is going to be December 31st. That was the question that occurred before the break. We know that the bridge moratorium also suspends late fees for a period of time until September 30th, but Senate Bill 5160 does it all the way up until the end of this year before late fees are going to be back on the table for landlords in any sense. Landlords cannot report to prospective landlords any non-payment by a tenant that occurred between March 1st, which is basically the start of the moratoria or the start of the pandemic, all the way through the 6 months after the expiration of the moratoria, which is going to be which is now fixed at December 31st. So any non-payment that occurs in that period, a landlord can't report that to another landlord or prospective landlord that the tenant's applying to move into. Any unlawful detainer for non-payment of rent also can't be reported during this period of time. So, I think the legislature understood that a lot of people are going to be facing non-payment issues, and they just took that off the table for a short period of time, or at least the reporting of that to new landlords. Prospective landlords can't take any adverse action against the tenant based on any non-payment that occurred during that same period of time, all the way from the start of the pandemic, all the way up until the end of this year. Adverse action is basically probably exactly what it sounds like. That would be, increased deposits, denying the tenancy. You basically can't use that as a factor in doing anything that you wouldn't do for a normal tenant or for any other tenant that didn't have that kind of issue. Prospective landlord is exactly what it sounds like as well. Anybody who's soliciting for a dwelling unit, that they have a dwelling unit available. So it's pretty broad based. Landlords and prospective landlords are not able to deny, discourage application, or otherwise make a unit unavailable based on some of a tenant's medical history, including their COVID status. This was a little bit of a quizzical inclusion to me. I didn't know this was a thing that was going on with any sort of regularity, but there you go. The language is in Senate Bill 5160. However, tenants can disclose or landlords can disclose for additional information if the tenant makes a reasonable accommodation request based on their disability. You could explore the contours of that a little bit. However, otherwise, their medical history isn't going to be useful to a landlord. There are somewhat stringent penalties for either a landlord or a prospective landlord who violates either of these, and that's 2.5 times the monthly rent, as well as attorney's fees and court costs. So, just keep this stuff off the table and you'll be just fine. Otherwise, you're going to have places like the Housing Justice Project, like trying to get some rent money out of you. Any non-payment of rent that occurred from the start of the moratorium period through 6 months after the moratorium ends, or 6 months after the governor declares an end to the public health emergency or greater, there's certain things that apply. So for any of those non-payment of rent, the landlord is required to allow the tenant or offer the tenant a reasonable schedule for repayment. And Senate Bill 5160 has a little bit of language, explaining exactly what it believes to be a reasonable schedule for repayment. And the court, in determining whether there's a reasonable schedule for repayment, is going to examine the tenant's circumstances, including decreased income or increased expenses due to COVID-19 and the repayment terms offered. And again, this is like the third time that I'm going to refer back to Valerie's presentation. She made a good point about decreased, decreased income or increased expenses during the pandemic period. People had to stay at home, right? They had to spend more money or order more food for eating out. The kids were stuck at home. So this probably covers quite a bit of different situations, and it doesn't take a whole lot of imagination to couch any sort of decrease in income or increase in expenses back to the pandemic. I've felt like this is probably a pretty easy sell to any court. So just be wary of this, before a landlord starts nitpicking as to what an increased expense or decreased income was during this period of time. Any repayment plan that's offered, the maximum monthly repayment could be 1/3 of the monthly rent during the pandemic period. We used the example of $1,000 before. The repayment amount could not exceed $333. That would be the maximum. The first payment under the repayment schedule has to be at least 30 days after the repayment schedule was offered to the tenant. These repayment schedules can only cover rent. They can't cover, late fees have been off the table for a long period of time, but attorney's fees or other fees or charges, this is rent only. And rent has a very specific definition in the Residential Landlord Tenant Act. The repayment plan must allow repayment from any source of income, including pledges. And so that's actually a little bit different, because we know a pledge isn't actually a tender of rent. It's a third party saying, I will pay the rent if you return this form back to me, if you give me certain information. Maybe it's a tax ID number or something like that. Landlords have to accept that for payment as part of, if a tenant tries to tender that as payment for under this reasonable schedule for repayment. These repayment plans are certain things that they cannot include in any circumstance. So a requirement that the tenant complies with other terms of the rental agreement. These are meant just to cover rent and to cure that arrearage. A requirement that the tenant applies for rental assistance, governmental assistance of any sort, or that the tenant waives any of their rights prior to the landlord seeking an eviction action against them. And the reason why knowing these rules is important is because it's a defense to a non-payment of rent eviction if a landlord didn't come into a reasonable repayment schedule that follows all these rules that we just discussed. Some takeaways from this. I know that I made this presentation initially, and I believe it was earlier this month, or I've done it several times. To my knowledge, the governor has not declared an end to the public health emergency. So we know that these reasonable schedules for repayment for any non-payment of rent is going to last 6 months past that. The moratorium already ended on June 30th, so we know at least until the end of this year. But until the public health emergency ends, it's these repayment schedules for non-payment of rent are going to apply 6 months after that, right? And so we don't have a date for that yet. We're still like moving into the future with that. Don't confuse that amount where the legislature stated that the maximum amount could be 1/3 as being what's reasonable. Reasonable is based on those factors that we talked about before. 1/3 is the maximum amount that a payment plan, a proper payment plan can include. And then you can't require tenants to seek rental assistance, but nothing prevents them from doing it. So don't get that language confused at all. It just can't be a requirement within the payment plan that they do so. Landlords have a couple different options when it comes to if there's a refusal of the payment plan. If the tenant does not accept a reasonable schedule for repayment, or then within 14 days, then the landlord can proceed with an eviction action subject to the eviction resolution pilot program requirements. I know Marilise is going to jump into how the ERPP works here in a little bit. And mind you, for that small period of time, there's the additional requirements of the bridge moratorium. A lot of these have some overlap to them, and they're kind of the same thing. But just know that if a tenant refuses a payment plan, and remember, you're going to have to be offering these payment plans for a long period of time into the future, or a significant period of time into the future. You're going to have to use the ERPP even after the bridge moratorium. If a tenant defaults on one of these payment plans, then the landlord has two options, right? The landlord can either move forward with the eviction, subject to the ERPP requirements and subject to the bridge moratorium requirements if we're in before September 30th, or the landlord can apply for reimbursement from the landlord mitigation fund. And I know Nicholas used a little bit different language here, and he's the expert in this, so I'll refer back to what his discussion was there. But the landlord mitigation fund, we saw that they're able, and I believe it was called the COVID relief program or something like that. COVID landlord relief program is what we're talking about here. I'm going to leave this alone. There we go. And I'm going to leave this alone here because I know Nick went through this, but that is an option if a tenant defaults on a payment plan, or if the tenant voluntarily vacates or abandons the property. Voluntarily probably being the key thing there. Accessing this money through the Department of Commerce isn't super difficult. It does require some work by a landlord, but it's not exceedingly burdensome. It does require a vendor ID number. However, that vendor ID number is pretty easy to obtain if you don't have one already. If the tenant vacates because of an eviction action by the landlord, then the landlord isn't able to access this money here. But if the landlord does choose to use this money for the relief program in order to get reimbursed, the landlord can't pursue any sort of legal action against that tenant for any remaining arrearage for a period of time. The eviction resolution program, we know this is going to be around for a while, right? It's going to be around in Senate Bill 5160. It's certainly around in the bridge moratorium. And so we need to explain that. And Marilise is going to jump into this and really give you the in-depth of what the eviction resolution pilot program is. But I will just start off the conversation by saying this is meant to facilitate the resolution of these non-payment of rent issues, because we know there's going to be a bunch of them. The court would be backlogged with non-payment of rent cases. They wouldn't be able, landlords seeking relief would be pushed months out if we don't clear some of these off the table by reaching agreements or by providing rental assistance or allowing tenants to reach rental assistance. DRC staff is meant that their skill set is to facilitate these kind of discussions, to bring the two parties to the table, even if it's been a rough pandemic period for everybody. But that is where their skill set lies. And they're neutral, they're not going to be on either party's side when doing this.
You've got a question here. Do landlords have to accept a repayment plan from the tenant? Such as, say, the tenant says they can only afford 25, is that supposed to be reasonable?
Well, see, and that's where we go back to the definition of reasonable that's included within the statute. If a tenant did have substantial amounts of decreased income, that might be reasonable, or increased expenses. It really may be. It's going to be based on the tenant's circumstances. And so I can't give a blanket answer that $25 is reasonable in every circumstance. I can't give a blanket answer that it's unreasonable in every circumstance. It really depends on that individual tenant.
Okay.
As dismaying as that is to hear for some landlords.
And we'll get into that in terms of the dialogue and the conversation piece. Can a tenant request the landlord mitigation funds if it is a subsidized unit, if the landlord is a housing authority is not choosing to go through the landlord mitigation funds?
I'll pick that one up. The answer is no. The landlord has to be the one to apply. They have to obtain the statewide vendor ID number. They have to submit all the documentation. And these are voluntary programs. So the one exception is the tenancy preservation program, where the tenant can request access to that while in court for an eviction for non-payment of rent. And at that point, the court can order the landlord to utilize the program. But for the damage relief program,
I'll go into that.
Okay.
Yeah.
But for the other three programs, the landlord has to choose to access the programs.
So here's a question for you, Mark, and I'm going to highlight that my mediators have the exact same question. So not only are landlords asking, and especially in terms of your timeline of what you just gave us, a 5160, what happens when a tenant does not agree to a payment plan proposed by their landlord?
Well, so, and they've gone through the ERPP process, right? That's what you're talking about.
I'm assuming not. That's my assumption when I read this question. And this is from Sarah Rash. If you want to clarify, Sarah, what happens when the tenant does not agree on a payment plan? I know I just saw Sarah's face.
So we do have a person who basically made a payment about 6 times throughout the year and has about $7,000 outstanding and set them up on a payment plan. They'll sign it, but never ever like agree with it or wanting to make the payment what's listed on the payment plan. I randomly get payments from them, which is like $200 every other week or at least every other month. So far we only have like 5 payments and they have outstanding money since January of this year.
And they have
Yeah,
not
so-
engaged in the early resolution.
Yeah,
Okay, so and you can look back in my slides because I'm going to make them available to everybody afterwards. But if you reach a reasonable schedule for repayment, you have 2 options, right? You could go forward with the eviction process subject to the eviction resolution pilot program. If they're not responding in that, you're going to be able to go forward with your eviction action based on that non-payment of rent. Mind you, there's some certain restrictions until September 30th, some extra procedural steps that you have to do under the bridge moratorium. You could choose that route. But if you have a payment plan in hand, and I believe Nick talked about this, there's options for you as well to recoup some of that money or a good portion of that money, I think within the dollar frames that you're mentioning from the Department of Commerce. So you have that option as well. So you could go either route with it.
okay. Thank you.
So what I'm seeing is the Alexis has about 7 and I think now 8 questions. We also have Nicholas and we have Carol. So I'd like to suggest that Nicholas first, then we listen to Carol, then we hear the other 7, and then we're actually going to talk about Sarah. The reason that we did that question, Mark and I, is one is a payment plan and accepting it, and the other is accepting the early resolution project. And that's what I'll come up with after we answer these questions. So the way we're going is Nicholas first, Carol next, and then Alexis, you are holder of all questions.
Thank you. Mark, you may want to follow up on this, but I did want to make a point for folks that have existing repayment plans that don't meet the standards of 5160. Do not use whiteout and manipulate that contract. You'll need to create a new contract and start anew with that tenant. Mark will speak to the legality of that, but we can't accept those at Commerce. So if you do have a repayment plan that they've defaulted on and it doesn't meet 5160, don't adjust it, just start new and start from scratch.
Yeah, and make sure that you have a complying payment plan under the terms that I mentioned under Senate Bill 5160. There's certain requirements that are there. As far as using whiteout on legal documents or documents that will be presented to the court that the parties didn't agree to, I think we could all reach a common ground in saying that that isn't the route that you want to go with any of this.
Carol?
Yes, very quickly. I got cut off right when you were talking about how if a tenant if a landlord applies on behalf of the tenant to a rental assistance program and the tenant does not put in an application, would that still be considered pending? And I did not hear your answer.
So the short answer, and I don't know if that was directed at me, I think it directed at somebody else, but the short answer was that my understanding was that would still be considered pending. It has not reached a final resolution. There hasn't been a final determination on it. Under the bridge proclamation, that's considered pending.
So I actually cut off my own foot then by trying to help the tenant, and then the tenant is able to extend their time period of unlawfully retaining my place because I tried to help them out and they're ignoring it.
Well, it's not necessarily that no good deed goes unpunished, but we're talking about under the bridge proclamation, you wouldn't be able to evict from non-payment starting on August 1st based on that reason. So remember, there's different rules that apply depending on when the non-payment's occurring. You could still potentially proceed on a non-payment of rent once certain conditions are met for non-payment that existed prior to that.
So on August 1st, if the tenant does not pay me for August, and I applied for them in June, you need to explain that a little better.
Okay, I'm going to suggest, Carol, let me give the presentation of what the eviction resolution program is and how we can help you through that, and then hold that question and re-ask it after I say what I have to say. Does that
Okay.
work, Carol?
All right, that sounds great.
Okay, all right. It's up to you, Alexis.
Thank you. So, would it be permitted to do a DocuSign e-document for the repayment plan, or does it have to be a hard copy? Jim or Mark, do you want to answer that question?
Jim hasn't talked too much lately, so
Sorry, I was multitasking. What was the question?
Question, would it be permitted to do a DocuSign e-document for the repayment plan, or does it have to be a hard copy?
Say yes, please.
You can use an electronic signature for the repayment plan.
Can a tenant request, oops, sorry, were you not done yet?
No, go ahead.
Okay. Can a tenant request the landlord mitigation funds if it is a subsidized unit? If a landlord is housing authority and is not choosing to go through the landlord mitigation fund?
That comes back to me. So if the landlord or the property owner is a housing authority, they're restricted from the damage relief program, not the other programs. So if a landlord chooses to go through any of the programs and they're associated with the housing authority, you'll need a subsidy to qualify for the damage relief program. But again, if the property is owned or operated by housing authority, they won't have access to that program. That program aside, it isn't relevant on any other program. We don't require subsidies. We just want to make sure that the tenant is low income, limited resource, or otherwise under financial hardship.
Thank you. Just to clarify, if tenant applies for help, they do not have to sign a repayment plan. Jim, do you want to answer that question?
Yeah.
Do you want me to ask it again?
No, yeah.
Okay. Yeah, so just to clarify, if tenant applies for help, they do not have to sign a repayment plan. Is that correct?
I don't understand the first part of that, but no, if you offer the option of a repayment plan, the resident is not required to sign it.
If the resident is saying $25 is reasonable, can we request proof of income?
You can require them to provide you a documentation to support the request. It may not be specific to proof of income, but it may include some sort of proof of income that, you know, so I think step one is that you could ask them to support the amount that they're proposing, and you can give them suggestions as to what. And if you look at the form that's provided by, it's on the Commerce's website, but then also I think at the AG's website, it does have a list of documents in which may be used in supporting the need for a different amount.
Thanks. Could you share that link with us in the chat, or the links where those documents are located? Let's see here. I have a HUD property. A resident was on market rent for a majority of the moratorium. Her rent has since decreased. Would the 1/3 of rent be based on the current rent or the past due rent?
The 1/3 be based on the past due rent, the rent that was due that they're repaying.
Okay. And then we have a couple more questions. How many times can tenants change the repayment plan? Sometimes they submit for 1 month and not follow the repayment plan, and so they keep resubmitting. Is there a limit to how many times they can come up with a payment plan?
So is the scenario that you offered them the option of the repayment plan, they signed it, and then they had 30 days for the first payment, 30 days after the payment plan was offered before the first payment is due. And then when the payment is due, they're not paying the payment.
Elisa, can you answer that question for Jim?
Yeah.
Lisa,
Well,
what's the scenario?
Scenario, yeah. So for example, I have a tenant who just submit payment plan, doesn't follow. Next month she submit again, but amount just accumulating and it's more and more, and she submit. So is it normal scenario when they just submit, but amount just growing, you know, but they're not paying anything?
If they're not, if they sign a repayment plan and then they're not able to make a payment when the payment is due, and they continue to just want to do another repayment plan on a new balance, I don't think that's necessary. I think that when you gotta maybe investigate what is the root of the reason why they're agreeing to the repayment plan, but they're not able to pay. Is there some sort of delay in going back to work potentially? Is there a, you know, that they anticipated going back to work and then something happened and that's why? So it's kind of a temporary delay, or is it something deeper than that? You know, if they're unable to pay, again, you know, if that payment comes due and they're unable to pay, you're eligible to submit the repayment plan to Commerce for reimbursement. My wondering would be, is your resident also at the same time, have they applied for rental assistance?
Yeah,
from
and and plus it's rental assistance pending. Mhm.
And then what is the status of that? So I think I'd look at the status of that, and then I'd look at how much.
Yeah, I will check with Valerie the status, because they're not able to update me. They told me, oh, it's pending, but I don't have any proof. And it's a good idea. I will check with Valerie what the actual status, because I was thinking if I'm waiting so long, maybe they deny it already and I don't know. And they just keep telling me it's pending.
Yeah, email me. I will be more than happy to look them up. And what I do is if they never submitted, so I'll search by your information, their address, their name, their email, any information you have, and I will send you screenshots whether or not they submitted, or if their application, like what status it is. If they are referred to a provider, I will directly link you to that provider so they can give you an update on the next step. So always feel free to email me and I will look them up for you.
Yeah, sounds good. Thank you.
You're welcome.
I will do.
Thank you. To clarify, last question, if a tenant applies for the county funding, are those months of rent excluded from a repayment plan?
Well, if I'm answering that, I would say yes. Well, I think that I would wait for the determination on the rental assistance, and if they're approved, if their application for those months is approved, then there's no need for them to have a repayment plan, because those are essentially paid, and you can focus on either rent going forward or months that are unpaid.
Do tenants have to submit the repayment plan to the landlord in writing and sign it?
The landlord provides the repayment plan to the resident, who then in return, if they accept it, would sign it and return it back to their landlord.
Are there any programs available for companies that manage properties for repayment of rent after the resident has moved out?
Nicholas?
Sorry, you got me multitasking. Can you repeat the question?
So there was a question about programs available for companies that manage properties for repayment of rent after the resident has moved out.
Yep, that's the Landlord COVID Relief Program. You won't qualify for the limited, but the Landlord COVID Relief Program is available to all landlords in the state of Washington. Repayment plans are only required if the tenant is currently residing in the unit, but if they vacated, you do not need that repayment plan. You can submit at any time.
Thank you. I think that's it. So Marilise, we're going to turn it over to you.
Okay, so you will notice that in Mark's wonderful presentation, he talked about dispute resolution centers, often referred to as DRCs. And if anybody is on this call, that means you care about Pierce County and you know that we are unique and particular in our own ways in many ways. So your center is not a DRC, your center is a CDR. And I just don't want you to get confused. It's got the same letters, we just mush them up. If you want to really care about it, it would be Daisy Stallworth as one of our wonderful founders. When it was created in our county, it was said the center is our first name because we bring people together to have conversations, and then dispute is our second name. So that's what makes us unique. And I want to shout out to Shanti. I'm also enjoying your group approach to Zoom. It's really fun to see human beings interacting and being together. I thank you both for sharing your video and heating along. It makes us feel like we're all together. I come representing a team of people who may look like calm ducks on the top of the water, but you should see the amount of pedaling that's going underneath the water. One face you get to see is Garrett, who for me is right in the center. There's very few people there. He's waving. And Mel is still having a dialogue with her camera. And that means Mel Humphreys cannot show her face.
I can't, but I can say hello.
And I just wanted to make sure, most important before we go too deep into what does the center offer. In essence, we exist to help having conversations when the parties are having a hard time communicate. And if you look at the last 20 questions that have come up, it's what about this? What about that? And ultimately, we're all trying to figure out what is this law and what does it say we have to do? But the law and the legislators and the intent of the county is work it out together and make sure you're meeting both the landlord and the business needs as well as the housing needs and figure out options. So I just wanted to sort of put that as the first. Now we're going to find out if when I share my screen, I lose the chance to see all of you. You're seeing it in non-presentation mode. And let's see if we can now see it in presentation mode. And I'm looking at your face. Great. Okay. So that is who we are. And if you see that symbol, you see those colors. We rebranded ourselves because the word dispute made almost everybody in our community turn around and say, oh yeah, other people have disputes, not me. And if we put dialogue in, it's a little bit more inviting. Oh yeah, I'll show up for a dialogue. But we don't talk for just talking's sake. We talk with a focus on reaching resolution. And I want to make sure that you knew that. You can go to our website, which I have on many of these slides, but we do have an interesting vision, and the eviction resolution program actually fits within that vision. It is that differences are resolved peacefully and respectfully while honoring diversity. And our community is Pierce County. And our mission is to resolve differences and strengthen relationships in community with inclusive and equitable dialogue. And that is clearly the way that we show up. For 27 years in our community, we have been doing mediations of all types, from anything that if you ended up in small claims about a security deposit with your tenant, you might have met us through that. We work on family law, we work in business law, and then we also train mediators and train community members, and we facilitate difficult conversations. I show up today to share with you our basic understanding of conflict. It's not going to meet with any of our legal beagle or our academics, but it really is a good way to think about conflict. It's when what happens is different than what you expected, and there's the gap that happens between that. And so a lot of our work is clarifying expectations, or when they're not clear, working with people to be able to get that clarity. So the role of the DRC, which is the Dispute Resolution Center, I've already told you we are unique in Pierce County. We have different letters, yet every form that you see will say the DRC certificate, the DRC, that's why I'm keeping those letters here. The first thing is if we're all about dialogue and resolution, since August of 2020, we have been available for both landlords and for tenants to hook them up to rental assistance, to make sure they're getting legal counsel. I'm sorry for the misspelling to all the legal beagles there. I didn't see that one. To have a conversation. It should say legal counsel. I spelled counsel wrong. I'm really sorry. We have been doing this since July of last year, and a lot of landlords, and I'm not sure how many of you on this call have already engaged with the center, and Garrett is very careful to be sending out giving you updates. So along with working with rental assistants and making sure we're getting clarity, he's sending out. When there's changes in the laws or the protocols, we've been informing both sides. Once the moratorium is lifted, which of course it did lift, and during this bridge process, we're still in a voluntary role until we get the standing order from the court. But for you as landlords to be able to show up and file at court, you must have a certificate from our center that says you've given the early resolution pilot project an opportunity. And so we're available to support you. One way to look at it is that the law created a speed bump on your route to court and said, go through the dispute resolution center. That's one way. And you could find us as annoying as any speed bump you ever walk over. We hope your experience with us is a pleasant one, is a productive one, that it's more about, let's take the time to clarify our expectations and figure out what needs to happen, and how to go about doing it. Given the amount of time that we have been talking to landlords on the telephone whose lives are in complete difficulty because they're not getting paid the rent or the income, and the tenants who are afraid that if they lost their job, they're going to be out on the street, we recognize that the pandemic and the uncertain recovery process has impacted everyone. And so our staff are trained from the very first phone call to guide you through the process to really approach this from a trauma-informed perspective, to make sure that we're listening to everyone. And I notice on Mark's, we don't have a side in this. We're interested in both parties talking, that you understand the impact, you clarify the goal for resolution, and then when you are in the dialogue, we're understanding those differences and reach resolution. It is possible, and I'm going to go back 2 slides, that if your tenant applied for rental assistance and the rental agency has not contacted them, by letting us know that you are trying to engage your tenant, we have already connected landlords and tenants in 726 cases that the rental assistants didn't have enough time to contact. I mean, we contact them by phone, by text, by email, by regular snail mail. Our staff are really working hard to make sure that we are connecting. And there's some really good reasons why people are out of connection. If you get all of your emails through your telephone and your telephone falls into the toilet, you now have lost telephone calls, text messages, and email messages. So our multifaceted way to try to reach out, we will recognize if you have reached out for the rental assistance and they've applied, and each side has their legal counsel and they do it, and you reach a resolution, you will never go through and access our services. You don't need a certificate. You're just going to keep on going. And the expectation, given statewide experience, is almost 50% of the cases will be solved with a payment plan, with rental assistance, and people will move on and continue. So we recognize that we exist for those really hard cases that you all are talking about. That it's either hard to get in contact with the tenant. Sometimes it's hard to get in the contact because they're now working and they're not open they're not available during business hours. We will find them, we will calm them down enough to explain that there are services for them, get them in connection with legal services. It's really important, given what we've all experienced this morning. Just think back, your head is kind of reeling with all the answers to all your legal questions, and not one of them was crystal clear saying a yes or a no. It's all kind of mushy. Yeah, so knowing that that's the way our heads are exploding, having us as the center offering different depths of dialogue while you get your legal advice, while you understand the facts of the case, that may be useful to you. So at this moment, we have 4 types of dialogue services. The first one is a deep intake, and it starts with a website, an intake form, and then it's a conversation with one of our staff, and that works for both landlord and tenant. And landlords, we have talked to a lot of you. We understand how painful and difficult this is and how annoying it is to ask your tenant to speak with you and not get any answer whatsoever. We also offer real quick conciliation where the landlord and tenant never really had a relationship, just pay the rent and get there, move on. We can do a real quick back and forth conciliation to be able to get to those payment plans that you're talking about. You're only offering me 25 and I want to have a third of the rent with every existing rent. We can have that conversation, and that's referred to as conciliation. It's not at the same time. One of our impartial mediators talks to one side, finds out what they want and what they can do, talks to the other, and between that shuttle on the phone, within 2 or 3 phone calls, we can come to a resolution. Sometimes one party doesn't want to talk to the other. That might be you're not getting the tenant to even have a conversation with you. The specialty of our mediators is to be able to open up dialogue in the midst of really difficult conflict. So we call this conflict coaching, which is preparing either the tenant who may be embarrassed, may feel shame that they haven't paid, they've never been in this situation, to get over those situations and show up as their best selves and work out an agreement with the landlord. Or we also do conflict coaching with the landlords. Mediation is where all parties are going to be right now for 2021, given how much of the law is shifting and changing. The only constant we can offer is we are offering all of our services virtually. So that means you can stay in your office, you can do a mediation, you can call in and have your attorney be present or not be present. We'll be offering that. Recognizing that not everyone has access to this kind of Zoom. We also have a building that has social distancing and the ability for somebody who doesn't have Wi-Fi or access to the internet to come in and participate. Even if they're at our center, they'll still be participating in front of a computer. And the last one is if both sides have attorneys and the attorneys would prefer to do the conversation about the landlord tenant, we facilitate those meet and confer style mediations. It might be everybody in the same room. It might be shuttle. We don't know what we'll be doing in 2022, but to get through the high volume we expect, it's going to be much faster if we can do both the mediation and meet and confer over the telephone. You'll want to know what our policies and procedures are and what are the rules and what is the timeline and what is the distance. And we promise that as soon as we get the court standing order, which may have happened while we were all talking here or happened last night and I missed it, give us 2 weeks to review what we have been doing during the moratorium, make the adjustment, and we will be publishing those on our website. But know that we understand each landlord and each tenant are unique and particular and have something different happening. And so what we're looking for is to have processes that offer predictability and consistency in our services, but at the same time recognizing the unique and productiveness of each dialogue. I want to be crystal clear. We do not walk in assuming that a payment plan is the only possible resolution. A productive conversation may be, I lost my job. I no longer can afford this unit. Let's get the back pay taken care of. And then let's figure out how I can gracefully exit and move on to another place. So I don't want you to think that our mediators are showing up with a solution already assumed. We're there to help facilitate and make that happen and possibly do some reality testing to say, you've got all the back rent paid, you've got income that doesn't allow you to actually pay the future. Should we be talking about other options? So as dialogue and resolution experts, we're used to doing what we call reality testing on both sides. So during this bridge time, and Garrett, you're going to put the email address into the chat. Any one of you, if you have not already registered with the center and give us your name and address and who your tenants are, go ahead and email this email address, which is solveit@centerforresolution.org. We have already hundreds of landlords that are in our system. So if your tenant says, I have done a rental and here's my confirmation, we can make that pairing and start that conversation right now. We do not have to wait for the bridge to end. That's what we've been doing. What is holding up a lot of the repayment plans is knowing how much there is rental assistance. But if what you're looking for is to speed up the process, once your tenant says, I can't do a repayment plan and you're going to start eviction, if you're already in our system, you have already tried dialogue, we will be able to produce that certificate much more efficiently and quickly than if you are just waiting for the tenant and waiting for the bridge to end, waiting for the moratorium to end and move on. So I really invite you all to start the dialogue process right now. And we have 726 cases that are all teed up already, which we know we're going to prioritize those who are in the system to figure out, can we get the resolution process or can we just issue the certificate? That was a lot of talking at you, and I need to stop so I give time for Mark and for Jim. But I want to go back to the first slide. The global pandemic and the economic standstill and the incredibly uncertain recovery process has impacted every human being who lives here. And sometimes when we're experiencing trauma, something happens. Someone raises a voice, we see a color, we smell a smell, we react as our worst possible human being self. We do not bring our best self to the room. So as an invitation, know that the Center and Dialogue is there to support you to show up as your best selves. Here's just some guidance. And even if you have to try to have your conversation with a party, before you initiate the conversation, get clear in your own head what it is you want to do, what it is you want out of this opportunity. And you may want an ongoing paying tenant and not have to go redo the unit. But for a paying tenant, that means somebody who's in communication with you. So part of the payment plan is not just let's get the back rent. Let's figure out when you have difficulty, how you're going to speak up and how we're going to work these things out and not let this many months of silence go by. So get your head on straight first of what you want and how this has impacted you. Many people have not heard how it has impacted landlords. The next is, before you start the conversation, consult with your legal rep. You find the legal support. You've got Jim Henderson here giving you landlord solutions. You've gotten a lot of information for Tacoma Pro Bono. We as mediators are asking Tacoma Pro Bono sort of to be the clearinghouse. If any of us have questions, that they're able to find the answer and publish it on their webpage. Get your head on straight, know what your rights are, because it's only then can you truly be empathetic and listen to the other side. When you show up, you know what you want to say, so go ahead and let the other party be the first one to talk. You may learn about their economic situation. You may learn more information. And then once you have listened and learned from the other side, you're going to recognize both have impacted, and you can make a plan that goes forward that is lots of different creative options. A hint, I can't offer you any kind of prescription to calm you down, but I can tell you there is a simple prescription for calming yourself down. 3 deep and profound breaths will bring you back to center and balance you when you're in a difficult conversation. And recognize your tenant is not so clear. So I love the fact that the woman who's with Shanti thinks I'm crazy and doesn't know what I'm talking about. It is scientifically proven 3 deep breaths will change your blood pressure, will move the adrenaline through your system. And it doesn't mean you have to agree with the other person you took deep breaths. It just means you won't react in a violent way that will ruin the relationship. So please, when you're, go ahead and sign up with the center, get involved with the center, get your tenant involved with the center. And for those of you who asked multiple times, what do we do about a tenant who has a pending application and no one is contacted? Go ahead and do the intake form for us, and we will do what we can to help find them. And when the time period has passed and it's time to issue a certificate, we've already done the intent to be able to connect with them and to talk with them. Often for some parties, it's easier for them to be able to, I'm trying to figure out how to stop sharing when I've got all your faces in front of me. Sometimes it's easier for people to say, I'll respond to the center than if I will, let me stop the sharing. It's easier for some people to be able to respond to the center because we're not part of the county. We're not a legal entity. We're not you, the landlord. We're not somebody who's in the officialdom. We're actually there to facilitate both parties getting what they need and to move on in a productive way. All right, that's it, Alexis.
Thank you. I do have a question from Shantae. Marilise, is there a receipt that you will send to let the landlord know you got the paperwork we submitted?
So you will fill out an online form, which Mel is in the midst of adjusting given all the new rules and the data we need to gather. You will get an automated email that will be in our system and recorded to you that you have started the process. We will be in communication with you. And then at the end, depending on if you reach a resolution or not, you will, and you want to go to court, you will get a certificate from us. So there'll be regular ongoing communication. And a receipt implies you pay for us. Right now, this is being paid for by the state and by the federal government. And the way you pay us is to give us all that data because boy, they want us to gather data. So you will get a confirmation and a thank you for sharing the data.
And Carol has a question.
Hello again. So I enjoyed the 3 deep breaths. I practice that quite often in my current job. The question that I have, can you hear me okay?
Yes.
It still didn't sound clear to me. So if my tenant does not respond to, over 3 months now, has not responded to the rental assistance email to them, they acknowledged to me that they received the email from them and then told me that they are going to milk this for 6 months. Then I would contact the resolution program. If they try to contact the tenant and are unable to get any response from them, how does any of that help me as a landlord? And by the way, I'm a low-income landlord and can't afford an attorney.
Right. So the way that this helps you is, first off, if you contact the center, even though you know they're in the system, we will reach out to them, we will clarify them, and the timelines that we need to stop talking so that we can get Mark and Jim back in begin to take effect. And so as soon as we get everything set up in our county, if they don't respond to us in X number of days, and I don't want to tell you exactly X number because it's going to shift a little bit in the next 2 months, but they will get an email, you will get a CC saying, we need to hear from you, or in that amount of time, and we've tried 3 different ways, we will issue a certificate saying we attempted to communicate with them in these many ways. And that's the certificate you're going to take that gives you the opportunity to begin the process of filing an unlawful detainer.
That was clear and concise. Thank you.
Okay, thank you so much, Marilise, for all of the work that you guys are doing and really taking the stance of like meeting right in the middle and hearing everybody's side, right? And not coming up with that solution for them, because I think a lot of landlords might, misinterpret what you guys really do. So thank you for explaining exactly how you guys help the parties create that solution together.
Okay, so really briefly, before we get to House Bill 1236, there's a few more things we need to run through in Senate Bill 5160. They're pretty easy. We're just going to hit the high notes and move right past them. So Senate Bill 5160, Washington is going to be the first state to allow or to require courts or have the courts have a duty to appoint legal counsel for indigent tenants that are facing eviction. We're not going to talk about this too much because it's not necessarily going to impact you very much. Tenants, there's certain standards that the court has to inquire about, whether before they make the appointment, the tenant has to be indigent or on some sort of public assistance. The right only attaches once the landlord serves the summons and complaint upon the tenant, then the right actually attaches. We're not going to spend too much time on this. 2 things that I do want to bring out about Senate Bill 5160 that landlords are going to have a particular amount of interest in, or should have a particular amount of interest in. There's new language. There's new form language for the 14-day notice to pay rent or vacate. So if you're going to be moving forward on any sort of eviction notice and, subject to all those requirements, subject to the bridge requirements, subject to the Senate Bill 5160 requirements, and you eventually get to the point where you're going to serve that notice to pay rent or vacate, make sure you're using the new form language that Senate Bill 5160 introduced back in April. specific information for tenants as far as accessing rental assistance and accessing legal counsel and things like that, or legal assistance, I should say, at that stage. So just make sure you're using the new language. You're required to substantially comply with that. Senate Bill 5160 also had new language for a summons. So if you're serving legal documents upon a tenant and trying to go forward with this eviction process, make sure you're using the up-to-date forms, because otherwise, you may run into some snafus that you're not expected. Just like the 14-day pay or vacate notice, this as well has additional information for tenants as far as accessing rental assistance and accessing the right to counsel that eventually, once certified, will be available to all indigent tenants. There's also a new tenant defense. This was actually came about in 2020, not necessarily part of Senate Bill 5160, although it did add something to it. And so this was all during the moratorium period where there was no non-payment of rent evictions. But a tenant who does face eviction and eventually gets to the process where a judgment is entered against them has the ability to ask the court to require the landlord to seek reimbursement of that full judgment amount from the Department of Commerce. And so just know that even if you're a landlord and you've moved, it could seem cumbersome. It could seem difficult moving through all these steps, all these hoops that you have to jump through, all these procedural burdens that have been placed upon you. Even when you get to that court process, a tenant's still going to have protections, including this ability to ask the court to enter an order requiring the landlord to seek reimbursement from the Department of Commerce. So you may want to explore that avenue ahead of time. In order for a court to do that, they have to find that a tenant is either low income, limited resource, or experiencing hardship. Limited or low income is the only one that's defined in the statute. I believe it's 80% of the median income for the metropolitan area. I would have to double check that exact language. I think off the top of my head, that's what it is. And until June 30th of next year, so 1 year after the moratoria lifted, courts can also, as part of requiring the landlord to receive this money from the Department of Commerce, the courts can authorize the Department of Commerce to issue up to 3 months of prospective rent on top of the judgment amount in order to stabilize the tenancy. So for some tenants who are just getting back on their feet and just getting back to work, this is going to be a really important avenue or right for them, or an option for them, I should say, when it comes time for the unlawful detainer eviction hearing once it comes up.